Welcome to Resolve Mediation Center Law Blog. We have with us today a very special and distinguished guest. If I were to simply list his accolades, his accomplishments, it would probably take the better part of the interview. However, I will highlight just a few. Our guest received his law degree from the University of Allahabad in 1967. He practiced law in the Allahabad High Court from 1970 to 1991, specializing in labor law, taxation, and writ petitions. He worked as standing counsel for the Income Tax Department. He was elevated to the bench of the Allahabad High Court in 1991. He was appointed acting Chief Justice of the Allahabad High Court in August 2004. Chief Justice of the Madras High Court in November 2004, and Chief Justice of the Delhi High Court in October 2005. He was elevated to the Supreme Court of India in April 2006, where he retired from this position on September 19, 2011, after serving the Indian judiciary for the better part of 40 years. He's been described this way, or at least his courtroom has been described this way, as one of the fastest in Supreme Court history, disposing of 100 plus matters a week. He has also been variously described as brilliant, bold, one of the best, a maverick. His strong belief in judicial restraint has been contrasted with some unconventional opinions he has delivered over the years. So without further ado, we'd like to introduce retired Supreme Court Justice and now currently Chairman of the Press Council of India, Justice Markandeya Katju. Justice Katju, welcome to our program today. It's an honor to have you.
Thank you.
Justice Katju, to begin with here, I'd like to ask you the very important question: how did India get into the dire circumstance it's in now judicially? It's been reported that some 30 million claims are pending in the judicial system today as we speak. How did this situation come about?
Well, firstly, because the Indian population has expanded. In 1947, when we got our independence, India and Pakistan, which was part of India at that time, had a population of about maybe between 400 million to 450 million. Today, India alone has 1250 million. And apart from that, people have become more conscious of their rights. They're more litigious. Cases are filed sometimes at the drop of a hat. The massive number of cases being filed. Society is changing. Just to give you one example, in our old society, there were hardly any divorce cases. Because in the old society, when people were married, the boy was married at the age of, say, 13, 14, girl was 11 or 12 years of age. Their parents chose their partners, and you were children, you were married, it was child marriage, and you grew up together. The boy and girl were more like friends, so the adjustment took place. There was no tension, they grew up together, so there was hardly any divorce. Now Indian society is changing very fast. Now, a boy maybe 28, 30 years of age, he's not a boy, he's a young man, and the girl is 27, 28, she's a young woman. She's also, many women nowadays are highly qualified. They were not so, there was hardly any women's education in the old times, 70, 80 years ago. Now many women are highly qualified, they're earning, and there's no dating system in India. So what is done at the time of marriage, that the boy and his parents come to the girl's parents' house, and the boy and girl meet each other. They meet maybe once or twice more, and then they ask whether they would like to get married. If they agree, they are married. Now suddenly you find yourself living with a stranger. Sometimes the marriage succeeds, sometimes it does not. And these young ladies nowadays, because they're earning their own bread, they're on their own feet, they're highly qualified, they have their self-respect, they will not put up with nonsense from the husband, which they had to in the old times because they were totally dependent on their husband's income. So because of that, there's a lot of matrimonial litigation. Tremendous amount of cases which is increasing. Every year the number of divorce petitions in India is double the previous year. And this trend has been going on for the last maybe 20-25 years. Divorce cases, maintenance cases, custody of children, whole lot of litigation. So I've just given you one kind of litigation which has increased dramatically over the last 10, 15, 20 years. Similarly, the lot of cases, for instance, a lot of cases are being filed in every court in India of check bouncing. Somebody gives a check, now that is not honored because they don't have the money in the bank, and that's been made a criminal offense. There are a large number of cases of that nature, which means commercial malpractice, the ethical level has gone down in Indian society. So for a variety of reasons, there has been an exponential growth in the number of cases being filed in our courts. All our courts are flooded with cases, with the result that now the time has come, we desperately need help from America in resolving our disputes, not through courts but by mediation or some other method. And here America has the greatest expertise. You, Brett, yourself are a mediator. You would be knowing that America is the homeland of mediation. And mediation is something which we have just started in India. In fact, I introduced it along with my friend Mr. Sriram Panchu when I was Chief Justice of Madras High Court.
So, Justice, what is the mediation process now in India, assuming that a process exists? What does someone who gets involved in the mediation system, what does he have to go through? Is it, can individuals involved in a dispute begin the mediation process of their own accord? Does it have to be referred to mediation? Can you explain the process there?
Now, let me tell you, we did not even know what is mediation in India. We only had adjudication. You know, India was a British colony, and the British set up our judicial system, the high courts and district courts and all. There was no Supreme Court. Appeals against the High Court went to a body called the Privy Council in London. That was similar to the Supreme Court today. So we had only adjudication. We did not know, we had not even heard of mediation. It was for the first time that we set up a mediation center in the southern state of Tamil Nadu, in the city of Chennai, which is the capital. I was the Chief Justice of Madras High Court at that time. I also I did not know about mediation. And when initially Mr. Sriram Panchu and some of his colleagues came to me, I thought this is some kind of a stunt, just a empty talk. But then when Mr. Panchu, who is one of the foremost mediators in India, very experienced mediator, he explained the whole concept to me. And then I thought that maybe this seems to be a good idea, let's try this. Initially, I can tell you, whenever mediation started anywhere in the world, there's a lot of hostility against it from both lawyers and from judges. Lawyers feel that if cases go to mediation, they won't come to us and our incomes will go down. So they are hostile to it. And judges feel that this is all nonsense, this is just a stunt. They will not refer the disputes to mediation. So it takes a while to overcome this initial hostility. We have to explain to lawyers that, look, you are the people who are going to go before the mediator. Most of the mediator is a lawyer, and the persons who appear before mediator are also lawyers. So you will get your fees from that. And in fact, I'm told that the lawyers in America who are also mediators, who are also trained as mediators, are earning more than persons who are only lawyers. This is what I was told by Mr. Sriram Panchu. And I was told that in the American Bar Association meetings, I think they are held every year, more than half the lawyers who attend are also trained as mediators. So initially we did not know anything about mediation. We learned we are in the initial stages of mediation in India. It was started in Madras High Court by Mr. Panchu and myself. We were two main persons. He representing the bar. I was the Chief Justice. I helped him. I gave him facilities. I gave him 5 rooms in the Madras. You please go to Madras High Court and see how it is functioning there, and with computer and with some staff and some furniture and all. I allotted all that. I could do so being the Chief Justice, and then they started. They've built up a huge setup there.
So if I might interject, then Justice, in the United States, mediation as a process can be entered into by the parties in a dispute prior to a claim being filed in court or a complaint being filed in court. Is that the same in India, or is it different?
Well, theoretically, it can be done in India. The parties can both apply to the mediation center in wherever in India it has been established. Please mediate our dispute
before filing a claim.
Before filing. And theoretically it can, but in practice that is very rarely done. In practice, once a case has been filed in court, then if the judge feels that this is a case which is more suited for mediation rather than adjudication, he refers the matter for mediation under a provision made in 2002 by Indian Parliament called Section 89 of the Civil Procedure Code. Section 89 of the, we call it CPC, Civil Procedure Code, gives the power to the judge in appropriate cases to refer the matter to the mediation center. See, every dispute is not suitable for mediation. Some disputes are eminently suitable. For instance, where relationships are involved, either family relationships, business relationships, commercial relationship. Certain disputes are ideal for mediation. If a man dies, the children start litigating for his property. It's better that is sent for mediation. If there's a firm with say 4 partners, they have disputes. If they go to court, and in India, cases take from district court to high court, Supreme Court, it may take 25 years. By that time, the business may be ruined. It's better that such case goes for mediation, where the mediator who is trained in mediation, he has to be a skilled mediator. He may be able to bring the parties to a compromise which may save the business or settle the dispute in an amicable manner. So that preserves the relationships also. Instead of becoming hostile and enemies to each other, the relatives or the partners or the shareholders, they are brought to an amicable settlement. And also it is fast, it is done very quickly, otherwise the case may take 25 years. A mediator may resolve the dispute in 4 months. So it's faster, cheaper, I think it's suited to India.
In your opinion, what percentage of cases that are filed roughly could be referred to mediation, and what type of case may need to be litigated as opposed to mediated?
Well, my guess is that something like 80% cases can be sent for mediation. In criminal cases, you can't mediate a murder case. If the man is charged for murder, that can't be resolved by. But petty matters, petty disputes. In India, we have a law that under the Criminal Procedure Code that certain matters can be, certain criminal cases can be settled by the parties by mutual consent. Petty matters, petty crimes. But serious crimes like murder or robbery or rape, these can't be resolved by mediation. That has to be decided by the court.
So by and large, the civil case, most civil cases, by
Yes.
and large, can be mediated.
Except where some legal principle is involved, where that requires deciding some legal principle. See, if some constitutional principle has to be resolved. You see, mediator doesn't decide anything. Unlike a court or unlike an arbitrator, even an arbitrator decides a dispute. Mediator doesn't. He facilitates a compromise using his skills, which he has acquired after getting the training of a mediator. He tries to bring parties to a compromise. Of course, if he fails, he reports to the court that I've been unable to reconcile the parties, now you please decide. So, my guess is 80% cases can be decided. In civil cases where some legal principle is to be decided, that has to be decided by the court. Because a mediator can't decide at all, he just tries to bring the parties to a compromise.
Justice Katju, in regards to once a mediation, a case has been referred to mediation by the court, how long does it typically or on average take for that mediation to conclude?
My guess is it takes around between 3 to 6 months. Now 3 to 6 months is much faster than 20 years. I know of cases coming before me both in the High Court in India and Supreme Court, where the husband and wife have been fighting with each other for 10, 15, 20 years. And I used to tell them that, look, you better resolve your dispute. Your hair will become white by the time this litigation ends. You started it when you were young people and now you will become old people. I had a case which had started in 1947 in the state of Tamil Nadu and coming up before my bench in the year 2008 or 2009. 60 years it took. Some cases take 50 years. It take a long time. If you read the novel of Charles Dickens called Bleak House, in which right in the beginning of the novel there is a mention of a case in the British High Court called Jarndyce versus Jarndyce, Jarndyce. And the case is before the Lord Chief Justice and it has been going on for 100 years, on and on. The parties are dead, their children are dead, the children's children are dead, the original lawyers are dead, then his junior who got this file, he is dead. Now the new lawyer does not know what the case is about, the parties don't, the descendants don't know what is the case about, they get a notice from the court, they start inquiring what. Things are not that bad, but it gives an idea. In India, it's like Jarndyce versus Jarndyce. Cases taking 50 years, 40 years, it happens very often. No, this is ridiculous. This is no justice. This is a mockery of justice. I'm sorry to say, but this is the truth in India.
Okay.
So that is why we need help from America.
Okay.
Because I was told that at one time in 1920s or so, you people were having also this problem that there are too many cases in court. Then you got together, some judiciary act was passed or some court management techniques were evolved in 1920s. Your judges and other administrators on the judicial side. And now you have vast experience in court management. You see, after all, deciding a case takes some time. You can't decide a case in 1 second. The judge has to read the papers. He has to hear the lawyers on both sides. Then he has to apply his mind, read the law books and so on. Then a high quality judgment can come.
Let me ask you, Justice Katju, in January of 2009, while you were hearing a petition filed by the Archbishop Raphael Chinath, I believe, about violence against Christians in Orissa, Justice Katju observed, and I quote, "We can't tolerate persecution of religious minorities. If your government cannot control such incidents, then quit office." End of quote. The bench directed the government to provide adequate security and compensation to the aggrieved parties.
You see, one of the hallmarks of a civilized society is that minorities in that society can lead a life of dignity and respect.
Can you highlight justice, just to interrupt, who is classified as a minority?
In India, Christians are hardly 3% of the population. Muslims are about 18% of the population. 80% people in India are Hindus. They are the majority. I am Hindu myself. Now in Odisha, there are maybe 3% Christian there also. It's one of the states in India. And one organization claiming to represent Hindus, they starting attacking Christians in the state of Odisha. And the Christians there fled into the jungles. Otherwise they may have been killed. And the case came up right up to the Supreme Court. I was a judge on the Supreme Court bench. And I told the lawyer of the state of Odisha that, look, the Indian Constitution has provided for religious freedom. Therefore, every person has a right to practice a religion. If you cannot give protection to minorities, you don't have a right to remain in office. Your government should better resign because you are not being able to uphold the Constitution, which you have sworn to do. We will not have oppression of minorities. So I said that this will not be tolerated, and these were oral observations, mind you, and but they had such an effect that stopped. So I am of the opinion that minorities must be given protection. See, I have written articles that both in India and Pakistan, minorities are often oppressed, often persecuted, which is very bad, and which I am sorry to say even about my own country, which shows that we are not totally civilized. If minorities cannot live with dignity and respect, you are not a civilized society. I don't regard you as a civilized society. So both India and Pakistan failed that test. In India also minorities are often persecuted. Muslims are often demonized as terrorists and all. The court of last resort, to my mind, is the best solution. Because people must get involved. You see, it is the duty in a democracy of people to see that justice is done. Don't depend just on lawyers and judges. Very often, poor people, minorities, they are victimized, wrongly accused, put in jail for years and years, some lying in jail for 10 years, 15 years, because cases in India take years and years to decide. Ultimately, even if he is found innocent after 10, 15 years, who will restore these years of his life which he has spent in jail? So, this is not how a democracy should function. In democracy, there should be justice even to the poor, to the minorities and handicapped. So, my concept was that the court of last resort is the correct solution, where people should get involved, not just lawyers and judges, but people must be who are spirited, who want justice to be done, who want that nobody should be falsely accused and put in jail. They should come forward, join this organization. We plan to have it all over India, with headquarters in Delhi, which is the capital of India, but branches in every state. There are about 26 states in India. And then right down to the lowest level, the district court level, or even lower down, where there should be a body of public spirited, socially conscious people who would like to help the handicapped who are languishing in jail.
Only lawyers, sir?
No,
only judges, or who?
Students, activists, academicians, whoever feels. You have to have a passion for this. You see, if you don't have passion, if you're just only interested in making money, you are not cut out for this. Of course, money is essential, but in addition to money, you should have a passion that injustice should not be done to anybody, particularly to those who are vulnerable, like minorities, like poor people who are more vulnerable to oppression or persecution. They should be given protection. So, This is a concept which I have in mind, and let us see when we can make it happen. See, 99% people of all communities are good, whether Hindu, Muslim, Christian, Jews. 99% people of all communities are good people. There are 1% wicked people in every community. But often in India, Muslims are demonized, that they are terrorists and bomb throwers and so on. Muslims have difficulty in getting jobs, difficulty in getting bank loans. Often they can't get houses on rent. And whenever any, say, incident of violence, some bomb blast takes place in India, the police is not competent to catch the real culprits, but they have to show they have solved the crimes. They catch hold of half a dozen Muslim young boys. This happens very often in India, and many of them are innocent.
So it's what we would call here racial profiling.
Yes, and there was one boy, Amir. He was 17 years of age when he was arrested. He spent 14 years in jail. After 14 years, the court found he is innocent. Now, who will restore 14 years of his life? This is happening on a very large scale in India, and there's a lot of alienation of Muslims in India. In Pakistan, it is the non-Muslims like Hindus, Christians, Sikhs who are persecuted, and even a section of the Muslim like the Shias, Ahmadiyas, they are persecuted. So both India and Pakistan fail the test of a civilized society. I am a very outspoken man, Brett. You know, you may have read all my articles on my blog, justicekatju.blogspot.in. I am a very outspoken person. If I think you are a thief, I'll call you a thief on your face. I am like that.
Justice Katju, I'd also like to ask you about a case that you ruled on, but more in the context of judicial restraint versus judicial activism. I know you've been quoted as having very strong views in this area. Can you elaborate for the audience your position in regards to those two subjects?
See, judges have their limits. We can't solve all the problems on earth. Many matters are best resolved by the legislatures or by the executive. Judges do not have the expertise, the technical expertise. We are not trained engineers or trained doctors that we can decide, technical disputes. And we don't have the financial resources. So judges must know their limits and must have humility and modesty. And the higher you go, as I said, in India, from district court, you go become a high court judge, then Supreme Court judge. Higher you go, the more modest and humble you must become. Because if you don't have humility and modesty, you may create chaos. You may, you may wreck the constitutional system. There's a separation of powers. There's a balance of powers between the three organs of the state. And the three organs must respect each other. Not that if the legislature or executive does something clearly unconstitutional, the judiciary should not invalidate it. Of course, judiciary has to do it if it is clearly unconstitutional. But otherwise, the judges should respect the legislature and executive and let them do their work. Then there is harmony between the three organs of the state. So that is what I have been saying, because sometimes I found that some judges, they cross their limits. They do the things which normally the legislature should be doing. For example, making laws. That is the job of the legislature. Or performing executive functions, which the executive has to perform. So that is my approach. We have to strike a balance. Yes, in civil liberties matters, the judge's duty is to protect the citizens against invasion of their rights by the legislature or executive. That's one of the sacred duties of the judiciary, that they have to uphold Like, for instance, the Bill of Rights in your US Constitution. Judges have taken an oath to uphold the Constitution. So in civil liberties matters, judges should be activists. But in economic regulatory matters, social regulatory matters, normally they must respect the view of the other organs of the state.
Are you familiar with Chief Justice Roberts' ruling in regards to the Health Care Act?
Chief Justice Roberts, in my opinion, is going to prove to be one of the great judges in the judiciary of America. His judgment in this health care case is a great judgment. You know, judges should ordinarily avoid confrontation with the other organs of the state, like Congress or the executive, unless what they do is clearly unconstitutional. Then they have taken an oath to uphold the Constitution. But otherwise, if two views are possible, one view upholding the constitutional validity of the law, the other is declaring it unconstitutional, they should try, if possible, to find a way to uphold the constitutional validity, which he did, deriving that power from the taxing power. Chief Justice Roberts said that the law is valid because it flows out of the taxing power of Congress. So I think he's going to be a great Chief Justice. I have great respect for Chief Justice Roberts. It was very easy to take a confrontation with Congress, but then that has very negative effects. One should respect each other. All the three organs of the Congress, executive must respect the judiciary, and judiciary must respect them. Then only the system can function. If you keep fighting with each other, it will lead to chaos. So Chief Justice Roberts' decision is a wise decision, and I hold him in great respect.
Well, Justice, that will conclude this discussion forum for today. I think I'd like to close by saying, of all your distinguished titles, accolades, and accomplishments, the one I am most fond of is the title of friend, my friend.
Thank you.
And I hope that the feeling is mutual and likewise.
It is.
And we look forward to our continued collaboration with you and the organizations that you serve as patron for. So thank you, sir.
My pleasure.
And until next time.
Thank you.